Good afternoon, Mr. Jolly.
Good afternoon, CJ. Jaji. Jaji.
Are you well?
I'm good, CJ.
Jaji, I'm sorry, Jaji. Thank you for correcting me. What qualifications do you have? Educational qualifications?
CJ, I've got BProc, I've got an LLB, and I've got an MSc in Transport and Maritime Management.
Did you do MEC after your law degrees?
Yes, Chief Justice.
Do you still get a chance to use it?
Not yet, not yet.
Okay. And practical experience that has prepared you for this position, what is it? Just in your own words.
Chief Justice, one has been a practitioner for years, admitted in 1999, and one was called in 2010 to act in the magistracy as a judicial officer until I became permanent in 2015. I went in 2020 to the Judges course in Maritzburg, sponsored by the Law Society, and I did also an advanced judicial skills course. So that has helped me in terms of preparation for this particular occasion.
When you acted in the High Court, were you not overwhelmed acting for the first time?
Chief Justice, one has to be overwhelmed, especially when I went to Free State to act. I was told that the matter that I was going to preside over, they needed a judge from outside the province. That rattled me because I did not know the reason for that. But obviously, there's a big difference between magistracy and the High Court. You would appreciate that when you sit as a magistrate, you write judgment for yourself. But when you sit at High Court, you write a judgment for a bench, so you're binding other people. So those things, one must take those into consideration. Safe to say that one was rattled, but because one was confident and did not want to fail, and indeed with the support of the judges, my former JP, Nathan Erasmus, and other senior judges.
And are there areas of the law that you are more comfortable with and those that you are less comfortable with?
I would not say, Chief Justice, less comfortable. One has been practicing civil litigation from day one. One considers himself as an expert in civil law, but he's not less comfortable by doing criminal law because the first time I did criminal matters was in High Court in Free State. Then last year in Cape Town as a magistrate, I dedicated a whole year to do the criminal law. So one is not that less inclined to do it, but one is most experienced in the civil litigation side of it.
All acting stints put together, for how long did you act? Have you acted?
I would say roughly 3 stints. I had a full stint in 2014, this stint this year in the third term, and April, May. I would say 3 stints, Chief Justice.
Well, how long put together? How many months put together? Were they terms? Maybe I was avoiding terms because once you say term, it may just be only lawyers who understand what that means. So it's easier when you say months.
I would say, Chief Justice, 7 months.
7 months.
I would say so, Chief Justice.
And one of the problems we have is producing judgments timeously. Has it been a challenge to you, or have you found it to be relatively easy to have judgment prepared and delivered before litigants have a reason to complain?
No, Chief Justice, from magistracy, even when I was acting, I never had problems of reserved judgments. I delivered judgments within reasonable time.
What about in the High Court?
Same with High Court, Chief Justice. There was no time where litigants would ask me, where is that judgment? Because the 3 months, even though in terms of the norms, it's 3 months, but sometimes I do it long before that, 1 month, 2 months, but it was never exceeding 3 months.
So to cut the long story short, you are ready, that is why you are here.
I am ready, Chief Justice. That's why I'm here.
Thank you. Acting Judge President.
Good
The
afternoon.
mic.
Good afternoon. Yes. There was a problem during the third term that has just come to an end when you were asked to do more duties than is normal. Am I right?
You're right.
It would have been
Chief.
something like five weeks of duty, but that was then rearranged to come down to 3 weeks.
Yes, yes, Chief.
Can you tell us how you managed that? How did it start? How did it end? Because I was worried about you concerning it.
Thank you. I'm indeed indebted to JP. But JP, one has taken an informed decision that one wants to act. And if you take that decision, you must accept that decision with all the pros and cons of it. You can't complain that you got 5 terms and it's abnormal. If you're given a job, you want to be a judicial officer, you just do the job as best as you can. To me, it would have been a problem, maybe, I do not know, but because, as you said, it was only 3 times doing duty. In any event, I did not think that duty in Port Elizabeth Court was out of this world. It was just normal duty, because you would see in a week there'll be 28 matters. There'll be 2 opposed matters. To me, I mean, that's normal, because in Free State I would have 80 matters or 120, I would have 6 or 4 opposed matters. To me, it was never an issue of doing duty 3-4 terms, JP.
Yes, and you were also asked to go to Mthatha to spend a week, I think.
Yes, I was asked to go to Mthatha, and the JP, I got a letter from the JP to say, at Mthatha, I would do civil duty, I would do civil trials, because Judge Alkem was going to be in East London, only to be told a Friday afternoon by the acting JP to say, where are you? Because we need to hear you supposed to do duty. Was when you start to do duty, you must be there a Friday before. I said, but JP, I was never told. The letter that I got, it says I'm starting Monday to do civil trial, but be that as may, I drove over Sunday and I did duty in Mthatha, which duty you would know the role of Mthatha is not a small role.
You managed it well.
I've managed it, JP.
So you did not pick up outstanding judgments?
No,
there,
no, I've never
which you
picked any
couldn't
judgment from
manage, yes.
Mthatha, JP.
So that would just be all about you and your acting stints in the Eastern Cape Division. You touch base in PE as well as Mthatha. In other words,
And
you
Grahamstown.
did not have chance to, and Grahamstown.
In Grahamstown, yes.
So you did not have chance to go to Bisho.
No, I didn't go to Bishop.
Did not have chance to go to East London Circuit Court.
No, no.
Okay. Those are my questions.
Thank you. AJP Premier.
CJ, I'll pass. I'm happy with the questions the acting judge president addressed.
Thank you very much, Premier. Any other colleagues? Any question intended to test suitability? Yes, Commissioner Nome.
Good
Your
afternoon.
mic is off. Maybe the AJP must switch off his.
I beg your pardon, thank you. Good afternoon to you. Sorry, there's just one judgment that you listed as being reserved. Have you since delivered that one?
Which one?
A judgment that is listed as I think you did it now in 2017. Sorry, I'll give you the date now. Yeah. Do I have the right one? Oh, yes. Oh, yes, the one that appears 9.6, Ludzia versus Minister of Safety.
Yes. Now that judgment, Commissioner, was delivered in the beginning of this term. It was a partial judgment of Grahamstown I delivered when I started this term.
So it has been delivered
yeah,
now?
Yes, yes.
Oh, all right. Okay, thank you. And then how did you find, having been a magistrate, how have you found that experience to be as compared to you now being, applying to, or having acted as a judge? How has it assisted you, that experience of having been a magistrate? Thank you.
That experience, Commissioner, assisted because you would remember magistrate is a stone face of justice. That's why you deal with litigants, the poor litigants for the first time. And it humbles you because you deal with poor people, you deal with all sorts of people. Unlike in High Court, because in High Court, most of the work is refined, if I may say so. But therefore, experience that you get in magistrate, it comes in handy, especially if you're one of the person like me, because I'm one person that I set very high standards for myself in terms of ethics, in terms of dealing with litigants, because I hold a view that litigants must respect court, must not be scared of court. So that is my view of a duty of a judicial officer in a constitutional state. So all in all that, it has helped and prepared me in terms of the smooth sailing to do work at High Court, even though at High Court, obviously work is more serious and small in terms of volumes.
Yes, thank you. And lastly, Chief Justice, sorry, you have read the criticism in the judgment by Judge Pickering.
Yes.
Have you, since now, you've reflected on the judgment and on the way you address the accused persons. What is your take on that? You had referred to them using their surnames, but without the Mr. or the Sir. How do you propose to deal with that going forward?
Commissioner, that was a judgment whilst I was sitting as a magistrate, and it was not commissioners, it was litigants. It was an attorney from the state attorney and a private attorney. And when I responded, actually I read the judgment a long time ago. I was not shocked when I got it as a comment, because I always wanted to respond to it, but you remember as a magistrate, you have no opportunity to take on the judge and take him on. I would say this process evolves, one from practitioner to be a magistrate and to an acting judge. It's evolved. You learn from the process. Some of the things, in that particular case, it was an oversight, glaringly an oversight, but it's not excusable. That's why I said in the response, I'm actually honored that the senior judges picked it up, because subsequent to that, there's never been that situation of calling a litigant, instead of saying, Mr. Mbofu, you say Mbofu. But there were reasons, because one has been a practitioner in PE for 16 years, and if you sit in PE magistrate court, if there's 10 matters on the roll on a Monday to Friday, 8 of those matters is Minister of Safety, and there's only 2 people, Mamase and Madogwa, and there's 2 firm of attorneys, McKenzie and Swartz. So it happens that you slip of tongue, you say Mamase instead of Mr. Mamase. It was really a learning experience, and I mean, I must take straw from that, and I said it has never actually happened since then.
Thank you very much. Thank you, Chief Justice. Thank you.
Thank you, Commissioner Norman. Commissioner Singh.
Thank you very much, Chief Justice. Mr. Jaji, I see you wrote a very interesting rejoinder to the criticism on the JSC's interpretation of Section 174(2).
Yes,
I think that should hold you in good stead since you are here at the JSC. But having said that, one of your qualifications is MSc Transport and Maritime Management at Antwerp. How do you think that qualification will assist you if you are appointed? Okay.
That qualification, Commissioner, will assist me, because if you look at the courses in that particular master's, you deal with advanced maritime economics and maritime management, you deal with shipping law, you deal with techniques of international trade, you deal with structural changes in the world economy. Having based in Eastern Cape, where you've got the port, the Kucha port and PE port, obviously there will be matters of oil pollution, there will be matter of attachment of ships. So all what you've learned in that course will come in handy in those kind of matters. I don't think it was a waste of time to do that particular master's program.
You know, no, I'm not suggesting it was a waste of time. Just the last question. Do you play any sport?
I used to play soccer, but I got injured. I don't play
Because I see you've got 2 good references from the Eastern Province Rugby Union and from SAFA. And this is the first time I've seen those kinds of references come through. Thank you.
Because, Commissioner, I sat in the disciplinary cases of all SAFA matters, soccer, also in the appeal cases, same with rugby. I sat in DC cases as a presiding officer and also sat as an appeals presiding officer. So I know a lot of that work from that particular.
Thank you, Commissioner Singh. Deputy Minister.
Thanks, Chief Justice. Good afternoon, Mr. Jaji.
Good afternoon.
Just one quick question. The post is in Grahamstown. You live in Port Elizabeth, and you've got at least one of your children is young. I see it's down as just over a year. Are you going to find place to, I don't know if your family will move to Grahamstown, but will you at least have accommodation in Grahamstown or are you intending to commute?
Thank you, Deputy Minister. Minister One originally is from Grahamstown. I've got relatives in Grahamstown. There's no problem to get accommodation. When I acted in Grahamstown, I was commuting. It was 1 hour drive. It was never a problem. So the issue of Grahamstown to me is never a problem. Whether I stay there full time or I drive in the morning, it was 45 minutes. And I'm based now in Cape Town. My child is at home with my wife. So it's not an issue that I'm away with my child.
Commissioner Msomi.
Thanks, CJ. Good afternoon.
Good afternoon, Commissioner.
Just 3 questions from me. The Constitutional Court has handed down in recent times very interesting judgments. I would like your view as to which judgment stands out for you and why, and how does that judgment contribute to the jurisprudential advancement of the South African legal system?
Commissioner, there's been a number of judgments that came from the Constitutional Court, but 1 or 2 that stands up to me. Obviously, one is that one of the Ngandla matters, and the second one is that of the SASSA matters. The SASSA matters judgment, to me, I think it would indeed enhance our jurisprudence because it dealt with what is very close to me, what is called judicial activism. Because indeed, in that judgment, you would see that from the Constitutional Court, there was indeed judicial activism, because if there was no judicial activism, we would be sitting here with a situation where about 17 million people are going to be losing their grants. And hence, I like the proactive manner of the Constitutional Court in terms of telling the administration, if you don't do A, B, and C, we will tell you how A, B, and C is done. And I think that, to me, in terms of developing our jurisprudence, even though one takes the point that in terms of judicial activism, there must be moderation, because indeed judges are not politicians. They're not trained in policy. They must give at least politicians to deal with policies. But when politicians are not doing what is supposed to be done by them, then the judges, in terms of the Constitution, are duty-bound, because the Constitution says judges make law as long as it's just and fair in an open and democratic society. So I don't see any contradiction. That's why I'm saying the SASSA matter to me, not because it deals with poor people, but it stands out in terms of jurisprudence.
Thank you so much. In that answer, you have answered one more question that I wanted to pose. So is it safe to say that at a philosophical level, as a judge, you are a judicial activist?
Actually, Commissioner, our Constitution demands of that, because remember, our Constitution makes a clean break with the past. And if the Constitution says judges must make law, because the whole stare decisis has been rendered obsolete. So now the judges must be judicial, but in as much as they are judicial activists, there must be some moderation. As I've said to you, judges are not trained in policy. They must not be seen to be overreaching. They must not be seen to be ruling instead of those who have been nominated by the popular majority to rule.
Finally, what is the role of the judiciary in a developmental state like our state?
To me, Commissioner, the role of a special judicial officers in a constitutional state, firstly, judicial officers, they are accountable to the community through their judgments, nothing else, to their judgments. And if they are accountable through their judgments to the society, therefore, it speaks to the quality of those judgments. That's why I'm saying, in terms of the norms and standards, judicial officers should understand that they are giving a product, and that product should be the best product. And on those bases, to me, they've got a very important role, because lately the judges, the judiciary actually has become the bastion of hope. And that's why you see a lot of many matters, especially political matters, coming to court. So you need to have a very, 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 very strict judiciary to be able to deal with those matters.
Commissioner Fourie.
Thank you, Chief Justice. Good day, sir.
Good day, Commissioner.
Everybody knows that or
at least people in the legal fraternity knows that we're sitting here interviewing candidates, and somehow they follow it, and sometimes they react. I've been sent a judgment on a summary judgment application that was apparently delivered this morning. I suppose it was delivered on your behalf because you weren't there. And that is the matter of Oryx Properties Limited and Ukuvula Investment Holdings. Does it ring a bell?
It rings a bell. It rings a bell.
I'm not going to deal with the merits of it because the respondent who lost in this matter can appeal if they want to.
Yes, Commissioner.
But I've read the judgment, and I must say, with all due respect, I found it a bit difficult to follow your reasoning. And whilst I appreciate that English may not be your mother tongue, some of the sentences are not entirely complete, and some of the sentences don't have verbs in them. So that's why I found it a bit difficult to follow. Can you just explain to me what happened in this matter? It's a summary judgment that was granted for over 4 million rand and lots of interest. Can you just explain the background, because I can't quite follow it from the judgment itself?
Thank you, Commissioner. Actually, I'm shocked if you say there's spaces and verbs and all that, because I wrote that judgment. Remember, the term is the second week we're out of term recess. So I left a message that it was to be delivered today. It was a summary judgment for a lease agreement where a company had some problems and it went on business rescue, and subsequent to that it was put under. But there was a surety signed. The company Ukubula signed as a surety. The person who's the director of Ukubula was also the director of the principal company. And it was for arrears, rentals and rates for almost 4 million. And there's no issue about that, it's common cause. But the only issue that they had was that the applicant did not disclose the cause of action. And number two, some of those matters might have been prescribed. And when you read the judgment, clearly a cause of action was set very clear by the applicant in that matter, and there was indeed no bona fide defense raised there, because the test is bona fide. There was never a bona fide defense. There was never actually any response on merits, only on technicalities. Where I stand, as the court does not deal with dilatory defenses and technicalities, the court looks at the crux of the matter. Substance is, to me, is better than form. And that's on those basis that summary judgment was granted, because there was never a defense, let alone bona fide defense. But my only problem is that I'm worried when you say, I have not looked at the copy that you've got. It's possible they might have given you the draft copy, I do not know.
Was this a simple summons that was issued?
Yes. Yes,
was all the required documents
they were annexed, all
attached
required
to it?
documents were annexed, and it's not necessary on a summary judgment to annex them when they were annexed on the summons. Your lease agreement, your acknowledgement that you're surety, they were all annexed on the summons.
Okay. You say in actions the principle is the same and applies. In a combined summons, the cause of action must appear from the particulars of claim. In a simple summons, from the body of the summons. What do you mean by that?
You can run that again by me?
You say in a combined summons, the cause of action must appear from the particulars of claim.
Yes.
In a simple summons, from the body of the summons.
I would have thought maybe it's the annexures, because there's no board on simple summons. I would have thought it's the annexures to that simple summons.
Okay. No, I'm just quoting what you wrote.
That's what I'm saying. Then obviously it's an oversight, the Commissioner.
Okay. When was this application for summary judgment heard?
It was somewhere in August.
Okay. And judgment was delivered today?
Yes.
Thank you, Chief Justice.
Thank you, Commissioner Fari. You're so well spoken. I wonder why you would miss out on verbs and so on.
But
if
that's
that
why,
be the case.
Chief Justice, I say maybe it's a typing error. I did not see
And
that.
the judgments you have written, those attached do not seem to suggests that you've got a challenge with the command of the language.
Yes, Chief Justice.
Yes, very well. Your excuse, sir.
Thank you, Chief Justice. Thank you, Commissioners.